Hello there. Welcome to our sharing with you on the Philippine legal system. And this time we're running another set of slides on criminal procedure under remedial law as part of our bar review in remedial law at the University of Manila. This time we will discuss about the jurisdiction which guides the public prosecutor in a criminal case where to go when he's ready with his resolution and information. We will show you in our briefs flow chart where jurisdiction is addressed during the subsequent sessions. The discussion on remedial law will cover not only criminal procedure but also civil procedure, evidence, special proceedings, and even the rules on summary procedure. And while this is intended to help those who are reviewing for the bar examination, it is really user friendly in terms of the manner by which we are explaining these concepts so that all of those Filipinos who deep within are frustrated lawyers can continue their education without having to come to law school and will allow them to understand and discuss intelligently with any lawyer who passed the bar and contend with the knowledge of the law or whoever claims to be knowledgeable on the law. And so, without much ado, allow me to introduce myself to you. My name is Dean Joe-Santos Balagtas Bisquera. I have a Bachelor of Business Administration, major in accounting, University of the East, and a certified public accountant, graduating summa cum laude. I have my Master of Business Administration, MBA, University of the Philippines, Diliman, magna cum laude, valedictorian. And my Bachelor of Laws, University of the East, cum laude, class valedictorian. After I finished my collegiate degree, I immediately joined the corporate world and rising in the ranks of managerial positions to reach the highest position in management as Executive Vice President and Chief Finance Officer of Fuji Xerox. The other companies I've been with include Motorola Philippines, GlaxoSmithKline, Esso that became Petron. I was also with Eco Asia, the construction division of the Manila Electric Company that handled the electromechanical component Bataan Nuclear Power Plant. I was with Delgado Brothers as controller and director for management information and financial services. I had a stint in the agricultural chemical field working with FMC Furadan, and I had the stint of two projects with the World Bank on the fishery sector and the local water utilities administration in water system when I developed their 10-year financial plan. So without much ado, allow me now to start the ball rolling by sharing with you some concepts on the Philippine criminal justice system. The criminal justice system is society's assurance of equality against the brute force of the jungle. Society values the fundamental concept that a person cannot be deprived of his life, of his liberty, and of his property. Of course, everybody can finish that without due process of law, as our Constitution would say. The state is called upon to protect society as a collective protective action in isolating and punishing social deviance where an offense against a particular person is deemed to be an offense against society. The Philippine criminal justice system addresses antisocial offenses defined in the revised penal code and all other special criminal laws and Supreme Court jurisprudence. The people of the Philippines is the real complainant in criminal cases, and the offended party only serves as the main complaining witness, while the Philippine society itself is the aggrieved person in the case of criminal acts. Just to share with you the first component of the flow of criminal procedure. Let us imagine now that there is an offended party over there in our picture on the left upper side of this slide, struggling to be alive after having attacked by a person. And that particular victim struggling there may or may not die. And he tries to go to the state to redress, in effect, to get the help of the state in order to punish whoever committed a wrong on his side. We already, in another slide, talked about his need to take a barangay certificate to file action, assuming his situation is not one of the exceptions to the barangay justice system. So when he files the complaint, he goes to the public prosecutor who receives his complaint and starts the preliminary investigation. The early things that the preliminary investigation would be involved in would be for the public prosecutor to issue an affidavit subpoena to the suspect named in the complaint. Sending the affidavit to the suspect, the system expects the suspect to respond and go to the prosecutor with this counter-affidavit to explain why he should not be prosecuted for the complaint filed against him. And he appears before the public prosecutor with this counterpart, and chances are the complainant may also be there to confront him. And the usual skirmishes between the victim and the suspect before the public prosecutor. The public prosecutor gets to assemble the complaint with all the attached documents like the police investigation report, medical reports, any object evidences that are available, and also takes a look at the counterpart affidavit of the suspect. The prosecutor determines whether there is probable cause that an offense has been committed based on the elements of a crime in the revised penal code, and whether this suspect must have committed the offense based on available submissions of evidences. When the public prosecutor is convinced that there is probable cause, he decides to file the case by way of a resolution that triggers also his preparation of an information. It is this information that officially triggers before the judge a case that will be subject to litigation. that information before the judge and with the resolution and all the attached evidences, documentary, object, or any other evidences are presented by the public prosecutor before the judge. The judge therefore has the opportunity on his own to determine the existence again of probable cause. And if he is convinced that there is probable cause that an offense has been committed and a suspect must have committed that particular offense, then the judge now will start the second half of the criminal procedure, which is the issuance of a warrant of arrest in order to gain jurisdiction on the person of the suspect. It is at this stage when the public prosecutor prepares his information that the next few slides will guide us on what the prosecutor will do by way of choosing which court does he file this information. We are talking about the two levels of the courts that this information can go to. At the lower level would be the metropolitan courts, the municipal trial courts, or the municipal circuit trial courts, or the second level of trial courts, which is the regional trial courts. So our subject matter in the next few slides is what cases would the information go to a judge in the metropolitan, municipal, or municipal trial courts, and what information will go to the regional trial courts. So we are speaking here of jurisdiction, which is supposed to be different from venue. Venue is simply the place, and usually in criminal prosecution, it is the place where the crime happened. Going now to the jurisdiction of both the trial court, regional trial court, and the municipal trial court on criminal cases. Let's take a look. In the area of the jurisdiction on criminal cases of the regional trial court, the first one is that cases not within the exclusive jurisdiction of any court, tribunal, or body, except if they are covered by the Sandigan Bayan, would go to the regional trial courts. So the regional trial court, all other cases, except those that belong to the municipal trial court or belong to the Sandigan Bayan or any other judicial or quasi-judicial body, will go to the regional trial court. Second one, actions affecting ambassadors and other public ministers and councils will have to be tried before the regional trial court. Third, the issuance of writs of certiorari, prohibition, mandamus, quo warranto, habeas corpus, and injunction enforceable within his region is triable by the regional trial court. There are three types of criminal cases that are handled by the regional trial court. We now proceed to the cases where the municipal trial courts are the ones that handle the trial. The first one, an exclusive jurisdiction over reckless imprudence resulting to damage to property regardless of the amount of findings of damages involved. So here, the municipal trial court would have to tackle all of the cases involving traffic collisions, violation of the contract of carriage between a passenger and a public service utility vehicle. Second would be cases involving imprisonment, where offenses with imprisonment not exceeding 6 years, irrespective of the amount of fine and regardless of other imposable accessory penalties or civil liability. And finally, violations of any city or municipal ordinances are triable by the Municipal Trial Court. So you will notice it's not very difficult to identify the relevant courts that would handle the cases. So the public prosecutor, who is in charge of prosecution of criminal cases, have only two choices and only three ranges of criminal cases for the regional trial court and the regional and three cases for the municipal trial court. It is very easy to identify, for example, reckless imprudence cases. Automatically, the criminal action on reckless imprudence, criminal negligence, goes to the municipal trial court. Or any offenses that do not exceed 6 years go to the municipal trial court, or any violation of city or municipal ordinance. If this is not any of the three, automatically it goes to the regional trial court, where cases not within the jurisdiction of the municipal trial court goes into, including, of course, imprisonment of offenses exceeding 6 years or exceeding 6 years. Okay. And so this is the range of cases handled by either the regional trial court or the municipal trial court. Let us go now to the civil cases. In the civil cases, the government is not directly in the crossfire because the people of the Philippines is not the one that is trying to file the complaint. So this is a private complainant having his right violated in exchange for example, in contracts, quasi-contracts, quasi-delict, quasi-delict. Now, let us first determine what are the civil cases under the jurisdiction of the regional trial court. The first one of the civil cases handled by the regional trial court would be the subject of litigation is incapable of pecuniary estimation. In other words, there is no monetary equivalent of the offense of the shortcoming or differences involved. Or if there is, it is difficult to estimate. The second type of civil case under the regional trial court would be the action involving title, possession, or interest in real property, so land, buildings, immovables, except for forcible entry and unlawful detainer, which of lands and building which belongs to, later on you will see, the Metropolitan Trial Court. Now, in the case of disputes on real property, in Metro Manila, the amount should be more than 50,000 for the trial court to have jurisdiction. Anything that is below 50,000 belongs to the local court, to the Metropolitan Trial Court. Outside of Metro Manila, the RTCs, for example, in Bulacan, in Laguna, in Cavite, in Batangas, in Cebu, in Davao, would handle the cases involving real property when the value of the property is over 20,000 pesos. The third civil case to be handled by the regional trial court are admiralty and maritime actions where the claim exceeds in Metro Manila 400,000 pesos. Or if it is outside of Metro Manila, 300,000 pesos. The regional trial court also handles probate proceedings. In Manila, in interstate as well as testate probate proceedings, as you know, the property of a deceased person cannot be distributed to his heirs unless they go through the so-called probate proceedings in court. The Regional Trial Court in Metro Manila has jurisdiction on probate proceedings where the value of the estate is 400,000 or more. And outside of Metro Manila, the value of the estate should be 300 more than 300,000 for the Regional Trial Court, for example, of Pangasinan, to assume jurisdiction. In the case of actions involving marriage contracts and marital relations, this is handled by the regional trial courts and the family courts handling, for example, annulment of cases or even legal separation and things like this. The special regional trial courts called family courts are the ones who are to have exercised jurisdiction on cases like this. Continuing with the jurisdiction of the regional trial court on civil cases. Cases number 6. Cases not within the exclusive jurisdiction of any court, tribunal, person, or body exercising judicial or quasi-judicial functions. Number 7. Civil actions and special proceedings. Originally, the exclusive jurisdiction of a juvenile and domestic relations court, essentially now the family court and the court of agrarian relations. And the last item, the last type of civil case under the jurisdiction of the regional trial court are all other cases in which the demand, exclusive of interest and cost or the property value under controversy is more than 400,000 in Metro Manila or 300,000 outside of Metro Manila. Continuing now with civil cases, but this time now we will go one step lower to determine the jurisdiction of the municipal trial courts. The first of the jurisdiction of the municipal trial court in civil cases would include civil actions and intestate and testate proceedings, including the grant of provisional remedies where the value of personal property, estate, or demand does not exceed 400,000. We all know that above 400,000, it goes to the regional trial court. Or in outside of Metro Manila, for example, in Baguio, the municipal trial court of Baguio, or if there is a metropolitan trial court in Baguio City, would assume the jurisdiction on testate or intestate proceedings for property values in excess, not exceeding 300,000. Forcible entry and unlawful detainer is an exclusive case belonging to the municipal or metropolitan trial courts. And the municipal trial courts have jurisdiction also over cadastral and land registration cases with no controversy or opposition, which the Supreme Court may assign whose value does not exceed 100,000 pesos. Number 4, action on the title, possession, or interest in real property in Metro Manila if it does not exceed 50,000 and outside of Manila if it does not exceed 20,000. And so, ladies and gentlemen, let us go back again to that first flaw of criminal procedure where we showed the offended victim and he goes to the public prosecutor to file his complaint. Public prosecutor issues the subpoena, while conducting the preliminary investigation, the suspect submits his counter-affidavit and sees the public prosecutor to allow the public prosecutor to determine whether there's probable cause. And when the probable cause is established by the public prosecutor, he prepares the information to file the case officially in court before, against the suspect. Our discussion on jurisdiction comes in at this stage of the ballgame where the public prosecutor, in a criminal case obviously, is confronted with where to file the information. And we have seen that it goes to the judge of the regional trial court where under three very distinct listings. And if the case does not belong to the to the regional trial court, then obviously it will be the metropolitan, municipal, or municipal circuit trial judges who will handle the determination of probable cause and the issuance of the warrant of arrest against the suspect in a criminal prosecution. So ladies and gentlemen, this completes our discussion of jurisdiction in criminal procedure under the rules of court. And so now you know what guides the public prosecutor in terms of filing the information that he has made because of his sincere belief of probable cause, and he now knows whether the case belongs to the regional trial court or the metropolitan trial court. We are ready to proceed to the next slides on criminal procedure. The first one is we will go through that entire stage of an offended victim, finally reaching the stage of the judge who issues a warrant of arrest. We will discuss the details of that in the following uploads that you will see and you can await. I'd like to thank you very much for following through with our series of lectures, and I hope especially the people, the ordinary person on the street. I would like to remember, for example, somebody, a good friend of mine, who used to drive for me and attends the hearings, and he would sit at the front view of the court and would listen intently and would be my probably number one fan whenever I stand up as the counsel to deliver my piece. And when we leave the court and we are on our way back to have either lunch or go back to the office, he would engage me in comparing notes about the case. I am referring to my good friend Mang Bal. I hope he's still alive and he can look at this. And when I finally ask him, Mang Bal, bakit ba ganadong-ganado kang sumama sa akin hanggang dun sa court? Nagmamadali ka pang iparada ang ating kotse para manood ka. Ang sabi niya, alam mo, Attorney Bisquera, ako'y engineering student second year. Pero ang panaginip ko talaga ay maging abogado. Kaya lang wala kaming pera, hindi ko natapos ang aking engineering. Ngayon ako'y kaibigan mo at kasama mo. Siguro para na rin ang feeling ko ay abogado kasi nandun ako sa tabi mo. Para na rin akong assistant lawyer mo na lumalaban ng bakbakan. Maraming salamat sa pagkakataong binibigay mo sa akin kahit ako'y matanda na. Parang ang feeling ko naging abogado na rin ako. So this little slide is my sincere dedication to my dear friend Mang Bal. Kilala mo kung sino ka. Kung sakaling buhay ka pa, sana mapanood mo to at ito'y dedicated ko sa iyo. Marami pong salamat sa lahat sa inyo who continue to watch all of the series, and I hope I'm giving you a little knowledge of the law that you can understand and appreciate. I'll see you in the next slides. So long.